And we're back. You're watching CNN. I'm Brooke Baldwin. Hulk Hogan is on the witness stand in Florida right now. He's testifying in this $100 million lawsuit against gossip website Gawker for publishing a copy of his sex tape. Now, Gawker.com says their defense is essentially they're protected by the First Amendment, that this was newsworthy for them. Lawyers for the site say Hogan lived a public life, and that is just part of that life. Minutes ago, Hulk Hogan on the stand told the jury about the first time he heard about the existence of this tape being out there.
My arms had never done this before. My hands started shaking violently, and I got off the phone. And I didn't go into a spasm, but it was one of those things where I couldn't quit shaking. David, I finally answered the phone back after David called me several times, and he talked me down because he was the only person that I had in my life that I believed loved me and actually just was my friend. And then that interview happened that afternoon, so it was probably 4 or 5 hours later. So I was pretty much on autopilot there, trying to just still make sense of everything.
Joining me now, trial attorney Marie Napoli and criminal defense attorney Philip Holloway. Wonderful having you both on, and we'll get to the crux of the case in a second. But Marie, let me just turn to you and ask you this. Watching him, one of the most recognizable, bandana and the whole deal on the stand, talking about when he first heard about the tape, is he sympathetic? Is he a sympathetic witness?
I think he's very sympathetic.
Why?
I feel for him. He seems like a genuine person. Unfortunately, he's a public figure, and it is of public concern. So I feel bad for him that he's going through this. But I don't think he ultimately will be successful in the case. No.
You don't. Philip Holloway, what do you think? Because essentially, he had this radio show. He was talking about his sex life. He is a public persona. Obviously his side maintaining this did him harm. What do you think?
Well, Brooke, it's not the fact that he's a public figure necessarily. That's a big part of it. But the thing is, as being a public figure, he injected his own personal life, in fact, his sex life, and some details about his marriage into the public conversation. So that is what is going to be the problem for him from a constitutional perspective. It's not. So
because he does that, that makes him fair game, even in a sliver of his private life. Right,
because even in a sliver of his private life, he talks about this stuff. He opens the door, so to speak, to this type of a conversation, and so now he wants to complain when a news organization, if you can call it a news organization, or somebody else puts this information out there into the public domain. In Florida, you can sue for an invasion of privacy on the basis of public disclosure of private facts, but the kicker is that it has to be facts that are not newsworthy. The question is, what in fact is newsworthy? And the fact that he's a public figure and he's injected this issue into the public conversation, I think causes him to lose in the long run. Maybe not with the jury, but probably on appeal.
Okay, here's what Gawker, this is their statement they released. Hulk Hogan was more than willing to talk about his sex life, I think to your point, including in 2 autobiographies, a reality TV series, and Howard Stern's radio show, until he didn't like what Gawker had to say, and now he wants $100 million as compensation. $100 million bucks.
$100 million bucks. I agree 100% with Gawker. Unfortunately, he did bring this into the public realm by writing about it in his autobiography and talking about it, so it is of public concern, and that's the issue. My law firm represented the woman in 50 Cent, and who we had a multi-million-dollar verdict against him. We affectionately now call him 5 Cent as opposed to 50 Cent. But the difference in that case was it was a private person with her private boyfriend, and the sex tapes were exposed by 50 Cent. So this is the difference between the 2 cases. Okay,
and Philip, let me just switch gears and ask you about Erin Andrews. I mean, incredibly compelling testimony from her last week. Well-known sportscaster, really worked her way up the TV totem pole, as I call it, and she was, she's suing Marriott for $75 million because some loser, held up a cell phone camera, put a camera through the people at her, hotel, and boom, next day there's naked pictures of her circulating on the internet. Anyway, do you have any idea which way that could go?
Well, with the jury, it's always hard to read the tea leaves, Brooke, but I tell you, if there ever was a sympathetic plaintiff, it is Erin Andrews. Everyone who has seen that testimony, and from my perspective, heard the testimony of her father, being a father myself, you know, it literally draws that emotion up into the case, and if the jury makes a decision based on emotion, she may very well get a pretty sizable verdict in this case. However, if you take emotion out of it and you step back and understand that a third party is only liable for foreseeable harm. The act of someone coming in and literally removing a peephole and putting a camera in there so that they can record someone, is that something that's foreseeable, something that Marriott is therefore duty-bound to prevent? That is really the $64,000 or $75 million question, I should say, in the Erin Andrews case.
We'll look for it.
But I do feel in that case, Marriott was asked what room she was in. They didn't know who the person asking was doing this, and he had already stalked this woman. So they put her in danger. They gave out personal information of where she was going to stay, and then booked the room next to her so that he would have access. I think, is it foreseeable that this person could do some substantial harm to her? Yes. This specific harm, maybe not, but I still think that they could be on the hook. And I think that's a good case.
The verdict will certainly make news, and we'll bring it to everyone when we know. Maureen Napoli, thank you. Philip Holloway, thank you both very much.